I'm well. Did you say your name is Anna?
Yes, I did.
And you're with Matt, is that right?
Sorry, I missed that question.
You said you're with Matt?
Yes, that's correct.
Okay. Is Matt
Before
the
we
same person
proceed,
that emailed
um,
me yesterday?
yes, that's correct. I just wanted to let you know that all of the calls at VI are recorded. Are you happy to proceed on that basis?
Yeah, that's fine. I'm
Okay,
going to be making notes at my end as well.
sure.
So if I pause, that will be um, in accordance with that. Okay, so thank you for sending me your email yesterday and calling me. Um, do you have a format for this, or would you?
No, look, really, I guess I just wondered whether you had any questions for us. I think I outlined in the email about our next steps, which would really be to ask IBAC for its file in relation to your complaint. Um, and then from there we would carry out an assessment just to really evaluate the handling of your complaint by IBAC. So that was our intention. Did you have any questions in relation to that?
Yes, and also I'd like to give you a little bit of a overview of what the essence of the complaint is. Um,
Sure, happy to hear that.
okay, so I'll start with the overview first, and then ask the questions, so you're in a better position to answer those. Um, in essence, my complaint against IBAC stems from the fact that they have effectively failed in properly considering two separate complaints that were made to them over the course of a year. And uh, the complaints arose from related matters, but um, they were about separate events, and they were against separate agencies. Um, I've had some ongoing issues with Victoria Police um, that started a few years ago, and I don't need to go into the details of those, but essentially, um, there is some animosity within the senior ranks at Victoria Police because of the manner in which I've previously raised complaints against different people. And in 2021, um, there was a tabloid reporter, Mr. Sam Kuchiara from A Current Affair, who started raising spurious allegations against one of my businesses, and effectively alleged that um, three out of I don't know, 1,000 people that the business had contracts with that year, whose the delivery of whose goods were delayed on account of COVID and um, other transportation issues, their goods were somehow improperly seized by me. Um, I was not involved in the operations directly. I'm the owner of the business, and then he essentially um, got those people in touch with the police here. The complaints did not arise from Victoria; they were about different states, and I'm still discovering a lot of this documentation from Victoria Police. But in essence, Victoria Police first contacted Consumer Affairs to advise that they were aware that they had no jurisdiction in this matter. The consumer law prevents them from acting on their own. And essentially, there were a number of things that were done improperly. My people broke into my house first by improperly influencing the real estate agent, and there was a plan orchestrated about how they will um, effectively procure a fraudulent search warrant, then film the events of the execution of the search warrant, have the people that were alleging that their goods had been improperly withheld collect the goods directly. The search warrant effectively allows the police to collect goods for adduction in evidence in court, and then there's a confiscation warrant that's required to confiscate the goods. None of that had been done. Fortunately, on that, plus the other issue is that the place where the goods were, it was a place, so during the pandemic, when the offices were shut down, I had rented a property just outside the city, which could function as a source where, as a place where trucks could load and unload, and some of my staff could work with me because offices were closed. So that was the property where the goods, some of the goods were the goods that weren't very bulky. Otherwise, they would be in warehouses. And I, as the pandemic restrictions eased, I stopped, residing at that property, and I was mostly in the city. So the police kept waiting for an opportunity to find me at the property, because they also wanted to execute the search warrant in a way that could allow them to arrest me, because then there would be no interference in the execution of the search warrant. Otherwise, they were concerned that I would get lawyers to inspect the warrant and so on. And the warrant was obtained under false allegations that I had an extensive criminal record. I have none. That is what was said in the search warrant affidavit, which has been disclosed to me now. And it was said that I am the director of the company, which I'm not. It was said that the contracts were, the consumer contracts were not with, well, it was said that the people had verbally spoken with me to engage me personally as the, I don't know, removalist of some sort. When there were written service agreements that those people had engaged, had entered with the freight transfer company. Now, that's how the search warrant was obtained. The police arrived at my premises on the day. I had been unwell, so I'd been resting late into the day. My assistant, who was also at the property, she in fact woke me up and told me that the police were in the backyard, and I initially thought that a truck driver may have hit someone and not stopped, and because the address was registered with a number of businesses in ASIC records and so on. So I thought they came to the premises because they wanted to locate the vehicle. So there had been an incident of that sort previously, where one of the commercial vehicles had gone into an accident. The police came to one of my properties. So I went out, I turned my audio recording application on the phone on to document the conversation, and the moment I got out, I was arrested and my phone was seized. And when my assistant Ms. Shu came out to film the event, she was also arrested and her phone was seized. Now, my phone was on recording and it was uploading the recording in real time to the cloud. The police was aware. They tried to turn off the app, as the recording later captured. And there was a lot of incriminating exchange caught. Apparently, the officer who swore the affidavit for the search warrant swore the affidavit after my removal from the residence had been facilitated by my arrest. So they removed me from the premises so they could bring the senior sergeant to the premises where the goods were. By the way, the house, the garage had a lot of goods from the accommodation services business that we had shut down following the pandemic, and we have receipts for all the goods which have been provided to the police. In fact, they tried to return the goods. Now, the issue is that all of this happened. People were caught on audio recording talking about how they didn't even have complaints for, to account for the goods that were at the premises, and they were basically seizing goods without knowing whose goods they were. And there was further evidence, some of which has been commented upon by Justice Ganay in his judgment. This was all provided to IBAC in 2022, shortly after the event, and they basically did nothing about it. And not only that, they also refused to categorize the complaint as a public interest complaint, which then led to a lot of reprisals against me, because immediately after discovering that the audio recording had been uploaded to the cloud, I had my lawyers send emails to the magistrates court, different people at Victoria Police and the VGSO. Now the VGSO immediately thereafter appointed Ms. Carol Orfanos, who I understand leads a team that's been managing the fallout from the Gorbo incident. And this, I've discovered communication between Victoria Police and her office about a campaign to start suppressing all the evidence of Victoria Police's improper conduct, including their communication with Consumer Affairs earlier, where they confirmed that they had no jurisdiction. And this was in fact, that day, the raid at my premises was facilitated at, it would seem, Mr. Kuchiara's behest. He was speaking with the police officers in charge, and one of their concerns was that the people that had been complaining about the delay in the delivery of their goods, they had received most of their goods back, and they were concerned that soon the remaining goods would also be delivered, and they would be deprived of an opportunity to effect the unlawful invasion that they did. So essentially, after IBAC refused to take further steps, first the police tried to refuse bail. They didn't provide me bail. They opposed bail, even though they had no evidence against me, as the magistrate noted at the bail hearing. And then they confined me to this residence, and the next day someone physically cut the connection, power connection to my premises, like with a, I don't know, I don't know the names of the gardening tools, but it was like with wire cutters or something.
Okay, and this was happening whilst you're on remand in jail?
No, on bail. So I was bailed the following day.
Okay, sorry.
But I was bailed under the explicit condition that I had to stay at the residence.
Okay.
At a particular residence. Now, I practically live at the office, so I was generally not there, and I would normally just rest at hotels near the office for convenience. But a couple of days after I was bailed to that premises, the power cables to the premises were physically cut off with with wire cutters or something. And
Mhm.
the evidence of all of this was provided to IBAC. Um, it was provided. It was filed in the Supreme Court proceeding, and also I've now discovered the internal machinations that were going on within Victoria Police and how they were speaking with each other about the evidence that I had and what they had to do in terms of getting aggressive lawyers involved who would oppose the disclosure of all documents and so on. Now, so that was the first issue. The second issue is that I had I've had an ongoing dispute with Legal Services Board, and it pretty much arises from the fact that I've been interested in covering. I've been interested in researching how administrative bodies abuse authority. I thought the Legal Services Board was a good candidate because of their position and the fact that it's generally a well understood fact that they're extremely aggressive with sole practitioners and so on. So I'd always engaged some lawyers to assist my businesses in their operations, and at some point I decided to formalize the arrangement by setting up an independent incorporated legal practice. And when the Legal Services Board commented on the current affairs story about the logistics business, I thought it was a good opportunity for me to commence action against the Legal Services Board as a trial for what I wanted to write about. And eventually it just became bigger and bigger. One of the lawyers that I had who was working on the matter, he was fired because he was not performing, and he was threatened with proceedings. So he basically went to the Legal Services Board and told them about what my plans were, or the specific person at the Legal Services Board who had commented on the matter. And that basically escalated into things, and ultimately they took some detrimental action. They effectively, I don't need to go into the explicit details of it, but they improper. Effectively, what happened is they argued that one of the principals of the firm was too senile to properly perform his job. So even after he had been replaced, they said that the investigator that had been appointed to assess whether or not the solicitor, Mr. McGregor, had the mental capacity to be a principal. So Mr. McGregor had ceased being the principal, and he had been replaced by Mr. Ansell. There were no questions about Mr. Ansell's ability to manage the practice. So Mr. Ansell was told that because of the board's concern regarding Mr. McGregor's capacity, an investigator had been appointed, and because the investigator had been appointed, they wanted to effectively go through all of the firm's files, and that included the files that the firm was maintaining against the LSP in relation to the lawsuit that we were commencing against them. Mr. Ansell thought it was improper for the firm to have to disclose the documents that it was maintaining against the Legal Services Board. So he indicated, he basically told me about the matter, and he told them that he felt it was best that the matter be the subject of a proceeding, and the court can decide how the matter should proceed. So, essentially, the Legal Services Board held him to have improperly obstructed the investigation of the investigator, whose investigation appointment certificate had clarified that the sole purpose of his appointment was to ascertain whether Mr. McGregor was capable of performing his duties. So it had nothing to do, there was no complaint that was made against the firm by a judge or by a consumer. No consumer could have made a complaint because all the consumers of their services were me or corporate entities that are owned by me. So under those circumstances, ultimately, when the Legal Services Board found an opportunity, they appointed an external examiner to the firm, because Mr. Ansell had not given them all the files, and they came in with a current affair reporters to the firm's offices when they took over, and the Legal Services Board came in, yes, and their appointed manager, and we were at the time suing the reporter in the Supreme Court, defamation proceedings which have now been halted on account of the fact that we want to get the search warrant stuff completed so we can add all of those matters to the defamation proceedings. So they brought in that reporter, and all of this was captured on video, by the way. It's been posted on YouTube. The reporter came in with the camera crew, and they filmed the content of the case files. And the Legal Services Board representatives were flipping the pages of the court files as the cameraman from Channel 9 captured their content, including the file that was maintained against them, and the Victoria Police, the Olney proceeding. And then after going through the content of the file, they asked the employees of the firm that were present on site, why we were commencing proceedings against Victoria Police, implying that we were vexatiously suing Victoria Police for them doing their job. Now, all of this was captured on camera. This was again provided to the Legal Services Board, and they didn't do anything about it. So I commenced proceedings against them at the end of 2022 for, I know that they have some discretion in relation to how they prioritize complaints, and I knew that it would be difficult for me to get them on that. So I basically focused on the fact that they did not classify the complaints as public interest complaints. I knew that they had no discretion on that. And they tried to have the proceedings against them dismissed on the grounds that, again, they have discretion and all of that stuff. So they brought in a summary dismissal application. The application was defeated. Justice Ganay found that, at least on that ground of public interest complaint, I had a reasonable prospect of success. But also, I think the result was better than I had anticipated, in that His Honour found that the evidence, and this has not been tested in the Supreme Court yet, but the police has admitted that the recording is basically a recording of the officers. They've admitted that in the magistrate court proceedings. But what His Honour found... That's right, the recording from my telephone. Now, what His Honour found was that the recording which has not been tested, but the evidence has been filed in the Supreme Court. If it is accurate, then it shows the police officers joking about killing me and about torturing my assistant, so she would give false evidence against me. And I mean, they stole things from some of the items that they took from my house, never made it on the inventory. They're caught on the recording. Those are cell phones, and there's an Xbox or a PlayStation. And they seized company vehicles which the search warrant had not authorized, and there are discussions about how they intended to claim that those vehicles were full of stolen goods after filling them up with goods. All of that was caught in the recording, and what His Honor found is that if the recording is accurate, then in fact His Honor could not. Well, I'm paraphrasing, but what His Honor said is that it would reveal systemic police corruption, not just an isolated incident of corruption because of the number of police officers involved. And in that sense, IBAC's argument that they have to prioritize the systemic police corruption, and therefore they cannot really be accountable for every complaint that they get, would also fail. So what His Honor found is that they hadn't in fact carefully reviewed the material, which was the only sensible explanation for how they could have not done more with the complaint. Now, in that proceeding, I had only challenged their dismissal of the police complaint and not the legal services board complaint. But as soon as IBAC realized that this was happening, and I had foreshadowed that I would sue them about the other complaint, His Honor had made directions about further progress of the matter. So IBAC immediately wrote back before the next hearing and said that they admitted that they hadn't even evaluated my complaints, some of my complaints. So their correspondence indicates that some of my complaints they never even evaluated it in the first instance, and the others they closed and they want to reevaluate. So they preemptively reopened the complaints even without me requesting them to reopen them, out of fear that I would sue them in relation to those as well. And then I had actually made a fresh complaint about the police, and I had done that tactically, as I clarified in the court proceeding, to prove that if I made the complaint again, they wouldn't dismiss it again because of the liability that would arise from a second act of misfeasance about the same complaint. So while His Honor was considering whether or not they had improperly dismissed the first complaint, I made the identical complaint again on the same evidence to prove to the court that they had already realized that they had made a mistake, because if they did it again, I would have another ground to sue them about the same thing. So they...
This is your third complaint. The first complaint about Victoria Police, the second complaint about...
That's right. That was the third complaint, yes.
And then the duplicate complaint
was about the first complaint.
Preparing his reasons for judgment.
No. It was... I actually did it while making submissions, so I could use it in submissions.
Okay.
Because... so the first complaint they had dismissed practically within a few weeks, definitely before the end of the 4-week period. So while the trial was on, or their summary application was on, it was heard over 6 weeks or so. I had made the complaint early on, and then I think we were already a couple of months or so into me having made the complaint, and they hadn't dismissed it. So I used that as evidence that they realized that they had made a mistake in the first instance, and therefore they were not dismissing this complaint just as quickly. In fact, this one should have been dismissed more quickly, because it was a duplicate of the first complaint, which had already been dismissed.
No, I fully understand.
Now, my problem with them is that they're now seeking to have the matter mediated behind closed doors. And I mean, it's not a problem in the sense that it's not causing a prejudice to me personally, but I am offended by the dishonesty of the whole matter, in the sense that they've now realized that they will lose this matter. One of the reasons why I'm suing them is so I can write about it, and also I wish to assist people that are in a similar situation with IBAC. I know that they dismiss most of the complaints, and people don't realize how they can hold them accountable with, especially with public interest determinations, in respect of which they have no discretion. So what they've now done is accepted that they had made some mistakes in relation to the matter, but effectively sought court orders about having the matter mediated. Those court orders were made by consent, because I had sought an undertaking from them that they would not have the determination of public interest nature of the complaints affected by the mediation. So my understanding was that the mediation would only be about the settlement of my claims against them, but they would not hold up the determination of whether or not the complaints were public interest complaints on account of the mediation. I had sought an explicit undertaking. Their counsel, so the court, the judicial registrar on the day, His Honor Kunidi, said that he did not see why there would even be a need to ask that, because obviously they would not do such a thing. Their counsel confirmed that, and then later when I corresponded with them about the ongoing delay in the classification of the complaints, because this is supposed to happen, the legislation says, as soon as possible, and it's been several years. They wrote back and they said this is something that we can discuss at the mediation.
Okay, which you were not expecting to be.
No. I mean, I didn't insist on a formal undertaking because of His Honor's remarks then, and then the counsel immediately confirming. So I'm now asking for the mediation to be vacated on the grounds that it was fraudulently consented to. But my bigger problem with all of this is that I think what IBAC is trying to do is that it's dealing with a public interest matter, in a manner which is clearly driven by conflict, and they're focusing on how to mitigate their own liability, arising from my ongoing and foreshadowed proceedings against him, rather than focusing on holding people that have done the wrong thing to account. And the manner in which they're progressing the complaints, the manner in which they're dealing with them, it's all about mitigating their liability. And that I'm finding extremely... I miss my grandmother's funeral because of the false affidavits that were sworn and the stringent bail conditions that followed. So I'm interested in making sure that some people that have clearly perjured themselves and fabricated evidence face consequences, and this is not simply about money. So I just want to... I didn't really need them to even hold the police to account. I was going to take care of that myself, but what I don't appreciate is the fact that they've made it difficult by keeping the public interest complaint determinations in which they had no discretion, and I could have sued them for detrimental action then, which I couldn't. And I also don't like the fact that now they're simply focusing on mitigating their liability rather than going after the people. And I mean, we've given them, the police has made admissions about affirming false affidavits, literally. And they're continuing to make more, and I mean, not easily, by the way. They've tried every angle. The magistrates wouldn't release the thing. I had to basically tell the magistrates that they'd have to hold me in contempt before dismissing my subpoenas because I would not accept the validity of their orders. I mean, I've really gone through the system and done a lot of research and played it from every angle to make sure that some people are held to account. But what IBAC is doing after getting all of this evidence served to them on a silver platter is simply using it in a way that mitigates their own liability. And the other matter is that the mediation has been delayed because I was always reluctant to go for mediation in the way they're proposing because it would have kept me from talking about the resolution of the issue. So they had initially proposed to have the mediation in March. Because I was reluctant and I didn't agree to it earlier, it was ultimately held in May. I'm saying this to emphasize that they were going to propose a resolution to the matter in March. But now, even at the end of April, they've not been able to classify the complaints as public interest complaints.
And so these are your complaints that are being reassessed unilaterally by IBAC at the moment. You still don't have a second and final decision about.
That's right, and that's the other problem. Like, I don't know what, I mean, they reopened these complaints, the second complaint at least against the LSB. By the way, I have an email from the police officer that affected that assisted the LSB in taking over the office on the day, to the informant Olney from the search warrant proceeding, telling him that the Legal Services Board has now seized all my case files and they have all the information about me and my associates. So if that police officer needed any of my confidential case files, they can contact this person at the LSB.
Okay.
Now, this is in evidence. This was discovered by subpoena. This is in evidence in the Supreme Court proceeding. IBAC has this information, and therefore they reopened the. I mean, there are emails about the coordination between Legal Services Board and the police. So the Legal Services Board's interest in all of this is that they want to assist in a conviction being entered against me because that would then help them in exercising their discretion to rule that I'm not a person fit to be involved in the operation of a law firm if there's a criminal conviction against me, and that would, avoid a lot of headache for them because of the work that I do. And the Victoria Police's interest in getting a conviction against me is then they can throw me out of the country. There's actually explicit emails between different police officers discussing the subject, that if they can achieve a conviction against me, they can use that to have my visa cancelled because I'm a permanent resident. And they talk about the need to do it before I gain citizenship and all of that. So IBAC has all of this information. These are documents that are discovered by Victoria Police. And they have enough information to reopen these applications on their own before there's further liability arising. But they're not classifying them as public interest complaints, which basically...
Is that the outcome that you're seeking?
So I would like Victorian Inspectorate to publish a report about IBAC's fault in not classifying these complaints as public interest complaints, because all that needs to be done for a matter to be classified as a public interest complaint is for the matter to disclose impropriety by a public official.
Well, it's certainly improper conduct. Yeah.
Yes, within the definition of the Public Interest Disclosures Act. And the threshold is fairly simple. It's dishonest performance of their duty, which is really not, it is not in dispute. There are admissions made by police officers. So I think this is important because I've done a lot of research on the subject. I've shortlisted and sent to IBAC and I think to the Victorian Inspectorate around 12 reports that were published within the last 2 years by IBAC about the most important problems that come up with Victoria Police corruption related issues in the reports that they've published. The fabrication of evidence, collusion between different officers to pervert the course of justice, the mishandling of investigation information. Those are key issues that are systemic issues. And those are the issues that are at the heart of this matter. There were several reports published about how police officers were affirming fraudulent affidavits to get search warrants, and there was apparently an operation in place, and the police union chief was implicated as the ringleader right at the time when my search warrant had been obtained. So all of these are issues which everybody knows are issues that affect the general public. And I think that if more people are aware of the fact that they at least have a right to get determinations in relation to the public interest nature of their complaints, it will empower them to at least be able to take subsequent steps in relation to detrimental action and so on. So my focus in all of this is to make sure that everybody is aware about the minimum obligation that IBAC has to deal with these issues, because in all of this I was never concerned by Victoria Police. I know that they're fairly limited in what they can do. I've been more concerned about the failure of IBAC, and also I've always targeted the Legal Services Board more because I think they have critical leverage on the system with the way they control lawyers and IBAC in relation to how they don't process complaints. And that I think is a bigger problem, because the individual officers, they react out of necessity when they think they're in trouble. But these people control the levers of the system, and they can easily affect wider change if they do their job properly.
Okay, I think I understand what you're saying. So, I mean, obviously Supreme Court cases are not quick affairs. What are the sort of the next steps?
So there's a mediation that's scheduled on the 7th of May. IBAC has scheduled it. So IBAC got my consent fraudulently, as I said, to the mediation because of the fact that they said they would not hold up the public interest nature of the decision in respect of that. So I wrote to them on the 12th of April requesting that they confirm their position in respect of the public interest nature of the complaint. They held back until the 24th of April, and then basically they wrote back immediately, and they said that because I had only given them 24 hours, And they immediately wrote back and they said that this can be discussed at the mediation. So I wrote back to them then a few days later, and I said that this was, I considered that to be a breach of their undertaking. Then they took, you know, 2 weeks to respond to that letter, to clarify their position about that. And they're denying that they made an undertaking. It wasn't an explicit undertaking. I had explicitly asked for an undertaking, but because Judicial Registrar Kunidi at the time suggested that it was unnecessary because there was no basis for my concern in that respect, and the counsel from IBAC basically confirmed His Honour's understanding of the matter. An explicit undertaking was not ultimately given or pressed, but I had made it clear that it was an indispensable condition upon which the mediation was being scheduled. So my issue now is that, like, 1 week away from the mediation, which was scheduled by court orders, they've made it clear that this is one of the purposes of the mediation. I've made it very clear that I'm not the person that normally negotiates, and they've made it clear that they're desperate to reach a resolution. I mean, you couldn't find a worse person to enter mediation with, because I'm pretty explicit about that. What they have said to the court is that basically they're concerned that whatever they discuss with me, I will publicize and openly criticize them about, and they want some confidentiality in this matter. I have previously used several ways of highlighting the dishonesty in the manner in which they're dealing with this matter, as evidenced by the second complaint that I had made and so on. So they're concerned about being embarrassed, and I think that there can be reasonable concerns about that. Sure, I think I have a right to embarrass them because of what they've done, but in any event, they don't get to use public resources to avoid embarrassment in the manner in which they're doing currently. And I think they have a conflict of interest, because the performance of statutory function should not be affected by the consideration of how they mitigate their liability. So what I intend to do now is raise an appeal against the consent orders on the basis of High Court precedent that they can be set aside if they're obtained by fraud, and on the day of mediation raise an argument that sections 14 and 15, or 15 and 16 of the Charter of Human Rights give me the right to freedom of conscience, and it is unconscionable for me to settle the matter with a corrupt agency or an agency adopting corrupt tactics, and therefore I have the right to not participate in the mediation with the intention of settling it. My concern is that if even if they agree to settle the matter financially to my liking or my acceptance, it would prevent me then from criticizing their failure to classify the complaints as public interest complaints, which I think is critical, because I and a lot of people I know have suffered detrimental action. I've received death threats, which didn't really bother me because I didn't take them seriously, but I know that other people working with me were affected by that, and they were also affected by that because I threatened to hold them to account if they acted on those threats. That's how all the work that has been done here. So I know that all that suffering and all that stress that I put everybody through should not be unanswered, and And my issue with IBAC mainly is that they're abusing the funds that they will have to do their job, to, you know, buy a settlement which prevents embarrassment to them. And also, I'm not sure how it will affect the complaint that I have initiated with Victorian Inspectorate, which is why I'm getting all of these things out before the mediation anyway. Um, so
All right.
those things.
I think what I would say, just in relation to a couple of your points there, is really there is no role for the VI in relation to like the mediation and any terms of agreement that might be reached in relation to yourself and IBAC. And whilst I've listened, and thank you for sharing what you just did for them, it's just not clear to me really I mean, I did understand the outcome that you were seeking is really a special report to be tabled in Parliament by the Victorian Inspectorate. What is quite unique about your matter is that it's still very, I mean, it is complex in terms of the involvement of the Supreme Court, the fact that IBAC has reopened and is reconsidering afresh your complaint, all of your complaint, I assume, whilst there's sort of negotiations and Supreme Court proceedings on foot. I'm just really
But it's
thinking aloud.
my point is this: either they made a mistake or they did not. I
And
mean,
you mean in relation to the first decision, which was...
yes, that's right. That's right. They dismissed both the complaints, and they determined that those complaints were not public interest complaints. Now, either they were right or they were wrong, because there is no discretion in this respect. The legislation is algorithmic. It says if these criteria are met, then they're public interest complaints. They have clearly done the wrong thing. I can also prove that it's dishonest because only after Justice Ganey came out with his decision, they immediately reopened the complaint without me needing to file or even prompt them.
Then you bring it full circle in terms of where we opened, which is, I mean, the role of the VI is definitely to review how IBAC has handled complaints that it receives, such as yours. So in circumstances where people raise concerns about whether there was really a reasonable basis for the petition or whether it was contrary to law, then the VI can seek a copy of IBAC files, and really what we would do is conduct our own review of that and make an assessment on whether we felt that those concerns were substantiated or not. And that's really the first step in the process.
Yes, and there's one other detail that I would like to provide you, which is that they, when I tried to serve them with the documents in relation to the court proceeding, they tried their best not to receive some of the affidavits because they were not strictly filed in the proceeding. So they tried to reject evidence of police corruption because they wanted to have plausible deniability. After the proceeding was started, when I was giving them further evidence of police corruption, they explicitly refused to accept it, and they said that I should confine the evidence that I was providing them to the evidence that was filed in the proceeding against them. The other evidence had been filed in a related proceeding, and a Supreme Court judge had ordered that I also provide it to IBAC because His Honor thought that the matters were very closely affected, and IBAC may wish to consider its position in respect of those matters because the outcome in that proceeding would inevitably affect the outcome in the first proceeding by issue estoppel and so on. So they may not have realized at the time that the judge had ordered me to provide them with the material, but they tried really hard, and they basically refused to open a Dropbox folder because it contained more affidavits than the ones that had been filed in the matter. And all of those things indicate that they were desperately trying to avoid a situation where senior officials would have to justify, their complicity in the failure to investigate the matter, even after they had later realized that it was a matter that should have been investigated. So, what and I think there's already a judicial determination about the fact that they're likely wrong. I know it's not a final order because it's a rejection of their summary application, but it's almost inevitable that they will lose the case, because the only thing that is to be decided is the authenticity of the evidence, which, as I said, the police has accepted. So I think from Victorian Inspectorate's position, there's no. I know you have to make your own decision, but a judge has already decided, and they're not challenging his decision, his honest decision, that the determination is right. The second matter that I want to raise is that I want to provide you with all the affidavits that were filed in the Supreme Court. So you have a copy of all the evidence that they had access to. I had previously.
Look, I don't think that's necessary. I think what we really require is, in the first instance, and I'm not saying that we wouldn't ever need it, but at this stage, I think we would start with seeking the IBAC file, which would contain the complaint and the information that was before IBAC and the decision makers at the time they decided that your matters were not public interest complaints.
But what about the fact? Okay, but my third complaint was filed on the 4th of August, 2023. It's now the 30th of April, 2024. They have still not confirmed that it's a public interest complaint. The third complaint in this case being the duplicate of the first complaint.
Okay.
Now, that complaint, this is the other problem with IBAC. What they initially tried to argue is that the only evidence that they would consider is evidence that was provided to them through a platform that they control, and they weren't giving me access to that platform to upload the evidence. Now, I argued in the Supreme Court that the Act basically says that any information that is given to them in writing is part of the complaint. His Honor has ruled on that and agreed with me. So, by that measure, all the affidavits that were filed in the Supreme Court, because they were served on IBAC officials investigating the matter. I mean, I've been copying everybody in just so I can prove that they were personally served. So I'm concerned about what files they will give you, because my position is that they had access to all the affidavits, at least by the 4th of August, that were filed in the Supreme Court proceeding, or most of the relevant affidavits, and they should be included in the matters. Now, they have not challenged His Honor's finding about that, and in communication with IBAC now, I have maintained that that was the relevant evidence. They're not opposing that indication.
Well, look, in relation to that third complaint, I think at this stage, if it's still under consideration by IBAC, I can't see that there is a role for us yet. In relation to the first and second complaint, what we would intend to do would be to seek a copy of those two files from IBAC and to assess those. That's not to say that we couldn't engage IBAC to seek some further information in relation to the third duplicate complaint. But at this stage, we definitely do not require all of your IBAC material. We would take this step by step. I don't expect that this will be a very fast and swift assessment. And our initial steps would be to seek the IBAC files in relation to the first two complaints.
But their website says that they determine the initial. So by convention, and I know there's no statutory obligation in this respect, but they take 4 weeks to assess whether a complaint is a public interest complaint or not. and on their website, and by the way, this was discussed in the Supreme Court, they've clarified this, and they say that in more complex matters, it may take up to 90 days. Now, in my case, it's been 8 months instead of 3 months in relation to a complaint which was identical to the first one. So really 2 years, over 2 years. And they've still not determined that it's a public interest complaint. So
when did you say it was lodged? On the 4th of August 2022?
2023, but it was duplicate complaint of the one that was lodged on, I think, the 10th of January 2022.
Yeah. Now, do we have the outcome letters from you in relation to complaint 1 and 2?
It should be there in the material that I provided, but I will send it again. I can send
it. If you could please send us the complaint reference number for the third complaint, that would be useful, please.
Okay, so can I ask this? How can I check with you what material you've received from IBAC in relation to what they say I provided them?
Well, that's a challenge because actually that information is provided to the really privately. It's not something that, for instance, we would make available to you.
But I think I have a right to know that because you can't really. I have a statutory right for you to investigate my complaint properly. There is no way I can assess whether you are able to investigate my complaint properly without knowing whether or not IBAC has provided you with all the information. So if I have to go through subpoenas, that'll be it. But I want transparency and integrity in this process. So I simply want to make sure that when you're evaluating the complaint, you have access to all the material that IBAC had access to.
Shavesh, I can't see the basis on which you would have an entitlement to access or view that material.
I think IBAC will be dishonest in the way in which they present the evidence that they had access to, because they've already tried to be dishonest about avoiding that evidence in the Supreme Court proceeding.
Look, I understand your reservations, but let's just take it one step at a time. So the next thing that we will do once we receive the outcome letters is just all of the complaints that we receive are in the first instance brought before our executive team, and that involves the inspector, the chief executive officer, and the general counsel, and the general manager of the operational area. And at that same time, we will be seeking their endorsement to engage with IBAC and to request copies of those first 2 complaint files, and potentially to engage in relation to the third complaint. And then, depending on the amount of material, we would ordinarily provide IBAC with a couple of weeks to provide us with those files, and then we will commence the assessment from there.
Okay, may I highlight a couple of things that you should look at, definitely?
Sure, go ahead.
So I would really like you to go through the transcripts of the court proceeding. I have had people extract just the arguments in relation to IBAC. I will give you the complete set of transcripts and also the extracted parts so you can verify their authenticity. Now, the extracted parts set out the arguments that both sides made in relation to how IBAC dealt with the matter. These were representations that IBAC made to the court about how they dealt with the matter, and it will be a check for you to make sure that they're being honest. It will also put into perspective some of my reservations about what they've done. And all the... Okay, great. And the second thing is that, again, I don't expect this to be a very quick process, and I've myself gone about litigation in a very elaborate way, which has taken several years because I wanted to get each bit of evidence. So, but whenever you do get all the evidence from them, I would like you to also accept evidence from me in relation to, or at least a list of documents from me about about what I had provided them. I think that's a reasonable request because it doesn't really increase.
Happy to receive that too.
Okay, great. So I will provide you with a list of. I'll provide you immediately with the complaints. I'll provide you immediately with the transcripts and the transcript extracts, and then I will provide you in the next 2 weeks with a list of all the documents that I had provided to them with dates about when those documents had been provided to them. So not the documents themselves, but the list of the documents. So
Like a schedule of the document.
index of, yes, that's right. And this will allow you, so with the affidavits, I will have all the exhibits to the affidavits listed. This will allow you to cross-verify whether what they're telling you they had received is exhaustive, and if ultimately Victorian Inspectorate makes the wrong decision, then we can at least be clear that it was not because of the fact that they didn't have all the evidence before them. Okay?
That sounds good. All right. Well, we'll wait to receive the details of the complaint.
Yes, you'll get that today. And am I writing back to Matt?
Yes, you are.
Okay. All right, Matt, I didn't speak with you, but I presume you're there.
Oh, yes, he's definitely here.
Sorry, I have been a bit quiet in the call, but I am usually.
Okay. All right. Thank you both for your time, and I will provide you with the information shortly.
Fantastic. All right. Thank you very much.
Take care. Bye.
Bye.